Right. Where do I have? Am I on? Okay. All right, everybody. Thank you. I would like to thank everybody for coming out today for Juvenile Justice. If the members will please take their seats, I would appreciate it. Ms. Chairman, you're welcome to come and have a seat. Yep. I'd like to welcome everybody here to the Juvenile Justice. We will be meeting today. We're meeting obviously today at 1, but we're going to be meeting every Thursday at 1 o'clock and 4:06 in this room. So just so you know, I'm fairly organized, which might be a little bit of a departure from previous chairman, but anyway. So, but we will be, and we do have a hard stop at 3. So I'm very cognizant and try to be sensitive to everybody's time. So we will be on at 1. We will be stopping at 3. Today we don't have much. We're just going to welcome everybody. We're going to approve the rules. I would encourage all the members to review the rules. They're in your folders. At this time, I will introduce the staff to our new members. Matt Wasatowski is our kind of our fiscal person, staff person that's assigned. And also Ms. Michelle, she is my secretary and she runs things. So everybody be nice to Ms. Michelle. So if members of the committee ever have any questions or concerns about the committee on a policy issue, please talk to Matt. An administrative issue, please talk to Michelle. So this is Juvenile Justice. We basically are entrusted by the General Assembly in the House, on the House side, with anything kind of concerning kids. So we deal with sensitive issues. A lot of times we deal with things that are of weighty importance, particularly for the future of the state, given that it's pertaining to the children. So everybody, I hope, at this point has had an opportunity to review the rules. Does anybody have any questions?
Move to adopt the rules, Madam Chair.
There is a move by Representative Quick to adopt the rules. Do I hear a second? There's a second by Representative Cantrell. All those in favor, please signify by saying aye. Aye. Any opposed? Thank you. The rules for juvenile justice are adopted. The second thing on the agenda today is HB 53. It's going to be presented by one of our members, Representative Mayor Margaret Oliver. This is for hearing only. Representative Oliver is going to take this opportunity to really frame the issue. It's a very weighty issue. We both traveled together to New York City to actually talk and had a seminar on the importance of this issue. So it has a lot of real impact as far as the policy and how juveniles are dealt with here in the state of Georgia. So we will not be taking any action, but we wanted to give Mayor Margaret, Representative Oliver, the opportunity to frame the issue for us. So if you would please. Also, for clarification, we will be hearing from Mary Margaret. Representative Oliver, I do apologize. She's my seatmate, so we're fairly informal, so I do apologize. But Representative Oliver will be, if she is going to be calling you to testify on her behalf, or if she has identified you as one of the witnesses to be testifying, then you do not need to sign up. However, there is a sign-up sheet if anybody in the general public who is not going to be called by Representative Oliver. There will be some public comments that will be taken at the end of her presentation. So, and I do understand that some members, bless you, do have conflicting meetings, overriding meetings, that sort of thing. So I understand certainly if people would just kind of quietly depart. I understand that I'm on 7 committees, so I certainly understand if you have a conflict. So anyway, with that, I will, Representative Oliver, please.
Introduced you to a major policy discussion that I anticipate in this committee, not a separate study committee, that we'll be having further inquiry in over the next year. The purpose of House Bill 53 is to raise the jurisdiction of the juvenile court to include all 17-year-olds for the purpose of criminal prosecution. 17-year-olds are already under the juvenile court jurisdiction for issues of abuse and neglect. But Georgia is one of 7 states left where 17-year-old minors, not legal adults, are treated as adults for the purpose of criminal prosecution for all crimes, traffic, misdemeanor, and felonies. That's a unique status. That number of 7 is reducing. In 2016, both South Carolina and Louisiana both raised the age. This bill is sometimes called RTA, Raise the Age Bill. Both Louisiana and South Carolina raised the age to include all minors for criminal prosecution in 2016. Mississippi did so in 2010, and the remaining 4-ish states that still treat minors as adults for the purpose of criminal prosecution are all in either discussion or specific legislation. There's a reason. This is a big policy consideration and a policy change, but the reasons for it are, for one, public safety, because that is, in our Georgia Constitution, our number one obligation is public safety, but also to protect minors from a criminal record that is going to haunt them the rest of their life. 17-year-olds with a mugshot and an arrest record treated as an adult can be better managed from the purpose of recidivism in the juvenile court system. And we have a great deal of data that will show that. The purpose of this discussion today is to introduce the issue, to talk about the history of this issue in Georgia the last few years, and to talk about the data that we have, and specifically the questions that we have about data. Because one of the reasons that I think it's very appropriate for us to spend more time on this issue, there are questions that simply are not answered. Numbers and cost are big inquiries that we need to make. And in your packet today, the people that will be talking about this bill have raised those questions and raised certain data that they will present to you, but also in your packet is a fiscal note. Under the rules, I'm required to ask for a fiscal note, and I did before the end of the year of 2016, and the fiscal note came in early this week. We are going to all, in a variety of different ways, raise questions about that fiscal note and talk about the data we have that contrasts with some of the data that we believe is true and the other data that we guess is true, to begin a really in-depth question. What would this cost if we made this policy decision to move the prosecution of 17-year-olds from the adult court system to the juvenile court system? What is the cost? With me today is my former district attorney and constituent, J. Tom Morgan. He was district attorney in DeKalb County for, he'll tell you how long, but I want to say at least 20 years. And he has written a book, Ignorance is No Defense, Teenager's Guide to the Law of Georgia. He's got a lot of experience and a lot of thoughts about the phenomena of the differences, the disparaging and difficult differences about how we treat 17, 18-year-old, 19-year-olds across Georgia. The Barton Center will come and present evidence on the data they have about arrest records. The Southern Center for Human Rights is here, and Voices are all in support. There's a national group that's been funded by the MacArthur Foundation. The MacArthur Foundation is the Genius Foundation. And one of the things that's interesting in my long political career that's changed is I've seen national foundations choose issues and decide that they're going to partner with states. And the MacArthur Foundation chose Juvenile Justice, and I think that's one of the folks that put on these conferences that Representative Ballinger and Chairman Wendell Willard, who is a supporter of this bill, he and I went to a conference funded in part by the MacArthur Foundation on this issue. And of course, Chairman Willard, you're welcome to join me here because you are a... Thank you. And he has a committee at 2, so thank you for attending very much. I'd like to clarify, for those of you who might be new, that serious crimes committed by teenagers are already in the adult system even prior to age 17, pursuant to what we call Senate Bill 440, what we call the 440 kids. Some of you might be aware that we passed a bill 20 years ago that provided a procedure for serious offenses by 13 to 16-year-olds, murder in the second degree, voluntary manslaughter, rape, aggravated sodomy, aggravated child molestation, aggravated sexual battery, or armed robbery if committed with a firearm. Those offensive, serious offenses, 7 deadly sin type offenses, are already have within the discretion of the district attorney to be transferred to adult court. So as we talk about this issue, please understand that we are not talking about the serious offenders. And as the other states have made this change, raise the age change, they also have addressed that issue. Serious offenders are dealt with in a different way. There were 7,452 arrests of 17-year-olds in 2015. The majority of these arrests, 72%, were for nonviolent offenses. What we don't know is how many of those were misdemeanors and how many of those were felonies, and we don't know whether they include traffic offenses. You know, traffic offenses are what touches most families, and they are what handled in very different ways, I will say discriminatory ways, in different cities and different counties. 23% of the arrests of 17-year-olds for larceny, 14% of the arrests for 17-year-olds were for marijuana possession in 2015, and the third highest arrest offense was for disorderly conduct. I was a former magistrate court judge. I had the Friday night shift at the jail in DeKalb County where I learned a lot. You don't learn those things when you go to bank board meetings, but when you go to the Friday night shift at the magistrate court, and dealing with disorderly teenagers is part of every weekend activity in low-level criminal courts. But I was still surprised to see that 14% of the 7,452 arrests were disorderly conducts, because those are the areas where you're going to choose on that particular instance, city by city, to give that 17-year-old an arrest record and a mugshot for life, or you're going to call his parents and say, come get this kid. I don't want to deal with him. Take him home. The disparity of that treatment is life-altering. And it particularly is life-altering in the area of the most minor but irritating teenage behavior like disorderly conduct and drinking. The history of Raise the Age has come before our leadership in terms of the reform of the Juvenile Court Code and in terms of the criminal justice reform. Specifically, when we passed, as you know, a major reform under Chairman Willard's leadership and sponsorship, 2014 of the Juvenile Court Code. That activity began earlier than that with the task, again with some foundation support, of drafting a model juvenile court code. What was the best practices? That was the first draft. In the first draft of the Juvenile Court Code was the provision to raise the age, to include all minors for criminal prosecution. Governor Deal, and I don't fault him on this, I think this was understandable and appropriate given his political concerns and the opposition that change of policy you'll hear about as we move forward in this. He chose not to make that part of the juvenile court reform. Similarly, the Criminal Justice Reform Commission, and I've served on that the first year, also has been asked at times as part of its juvenile court justice reform to raise the age. And I think they're considering that. You will hear real issues of cost and real issues of management. But this is not a new issue, and it's an issue that is of national direction and leadership, and it's an issue that affects, again, as our 8th largest state in the United States of America, thousands and thousands of teenagers, many of whom may be constituents of yours, and certainly people that you are close to are touched by this issue. The interesting thing to me, and I'll move right now to the fiscal note. The interesting thing to me is, can we really predict the numbers of what this would impact in terms of our cost? Because of two major factors that are moving targets. Juvenile offenses have dropped nationally and in Georgia significantly, 30% over the last dozen years plus. We're having a reduction in juvenile crime. We also are having, based on the good work of Governor Deal and criminal justice reform, we're having a reduction of hard beds in our juvenile court system. I think, and I'll be corrected on this if I'm wrong, we have eliminated almost 300 hard beds from the Department of Juvenile Justice. We are trying again and again in various ways to make sure that the hard beds are used more specifically for the most difficult hard criminal offenses. We know that recidivism rate is dramatically lower for juvenile offenders than it is for offenders in the adult system. That's a hard one to measure too, because you already know that the 17-year-old 440 kids are in the Department of Corrections jurisdiction, so you might guess that their recidivism rate might be more difficult. So that's something I want to explore further. But I do believe that in that the juvenile court requires a multitude of programs and approaches like restitution, like mandatory school attendance, the kinds of things that are not treated with attention in the adult court, see the state or correction or felony, whoops. I fit in the jar. Thank you. That's much better. Thank you. So the recidivism rate is an important question. In that juvenile courts provide more services, more oversight, different kind of attention, it is expected that they would have a different, better outcome of recidivism rate. Recidivism rate for low impact offenses, no violent offenses, have a better recidivism rate. So the recidivism rate is a key factor in terms of public safety analysis. Let me address the fiscal note, and I'll just give you a little pushback on it. When this issue first came up, the powers that be did an analysis. I think it was around I'm not sure what year, but several years ago, and they came up with an impact number that was larger than the impact number they have here. This number is suggesting that the Department of Juvenile Justice would need 3 additional 50-bed facilities. That makes no sense to me because there are only 90 70-year-olds in the Department of Correction today. Only 90, and most of those are 440 kids. So if you have a reclining rate of incarceration for nonviolent, and if you have a declining rate of crime, and you've already eliminated 200 plus hard beds, why would you need 3 additional facilities? Those numbers don't make sense. It's also true that we spend more in juvenile court than we spend in adult court, but to the extent our criminal justice reform packages are being effective in reducing recidivism rate, reducing cost affected in relation to oversight of nonviolent criminals, this move of reform to raise the age will continue to lower the cost of criminal justice. And if you look at the studies, and I won't go through all of that today, if you look at the studies of the other states, dozen which that have changed this law in the last 20 years, and again, the last 7, 3 in the last 2 years and the last 7 that are left, their analysis is that there have been reduction of cost and not so much the addition of cost. So as we go forward in relation to studying this issue through the leadership of this committee and the leadership of criminal justice reform, there are questions about data we need to explore. There are questions about recidivism rates. Are we going to continue to do better in juvenile court? And there are clear questions of cost. But there are very few questions, and this is what I'll leave you with. There are very few questions about the policy consideration of treating minors as minors under juvenile court versus treating minors as adults for the purpose of criminal prosecution. I hear very little pushback on the policy of 17-year-olds being treated in juvenile court for criminal prosecution instead of state or superior court, but I hear real questions that we will explore on what is the cost of such a significant policy change, and do we want Georgia to be the last of the 50 states that continues to prosecute minors as
Thank you. I appreciate that, Representative Oliver. I just wanted to briefly point out to committee members, particularly those, if anybody might be contemplating, if at any point in time there is a committee sub or anything like that, point out our wonderful legislative counsel that we have assigned to juvenile justice, Ms. Jill Travis. So if anybody has any questions about committee substitutes or anything like that, then Ms. Travis, I'm certain, will assist.
Madam Chair, would it be appropriate for me to ask the first witness to be J. Tom Morgan?
Yes, that would be fine, Representative Oliver. However, Chairman Welch has a question. Chairman Welch.
Thank you, Chairman. Okay, that's working now. Representative Oliver, going to the fiscal note questions that you're raising, I too have some questions about this note. I would tend to agree with you that this doesn't logically make sense on the face of the document, that there are questions and things of uncertainty, statements made in the document that raise uncertainty as to cost, but we already know the numbers that are currently coming into the system as 17-year-olds into the Superior Courts, and we're already providing public defender representation where that's necessary. And likewise, we have prosecutors who are prosecuting those cases. Those are knowns. I mean, this isn't an unknown. We're not talking about a new fluctuation of potential defendants. So it doesn't add up to me as to why we would need more prosecutors. It seems like to me we would be moving prosecutors. So we'd be shifting caseload burdens in prosecution and defense downward into the juvenile court system as opposed to needing more. So I have some questions about this too. I don't see I like you have some concerns about the nature of this note and the unknowns that it seems to raise when these are readily knowable data in my opinion. So I think I'd like to kind of explore that with you as we move forward with this concept. That's not an endorsement of the policy change. That's just simply a question about getting accurate data so that we can know what the cost of such a policy change would be to the state.
Thank you. Here's a question we have no idea about that. You think we know certain things clearly. We have no idea how many 17-year-olds are in jails today, local jails. None of the data that we know 7,452 are arrested, but we don't know how many days they spend in a jail. That's an example of, should be a knowable fact, but might not be knowable.
But we may not know the number, but we know that they are in the process of being prosecuted or have been prosecuted, correct? Yes. So we know that the system itself is already prosecuted and defended, or is in the process of doing so now. So that's more to the idea of how many more prosecutors or defense attorneys we would need that's stated in this note. So I have some questions about that.
Thank you. I think that's going to be very much at the center of the debate that goes forward.
Thank you, Chairman Welch. If you want to go ahead and call your first witness, for the other members of the committee, if you'll just hold your questions, please, until the first witness gets finished. Thank you. Mr. Morgan, welcome.
Thank you. Good to be here.
Which one do I turn on for him? Okay.
I'm J. Tom Morgan. I grew up in Albany, Georgia. Attended undergrad and law school at the University of Georgia. After graduating from law school, I went to work in the DeKalb County District Attorney's Office, where I was a prosecutor for 25 years, the last 12 years as the elected district attorney. Since leaving the District Attorney's Office, I've set up my own law practice in Decatur, where 90% of my clients are under 25 years of age. I authored a book, Ignorance is No Defense, A Teenager's Guide to Georgia Law, which now we have almost 70,000 teenagers and their parents who have copies of it, hopefully are more informed about Georgia law, and also authored Ignorance is No Defense, A College Student's Guide to North Carolina Law. I am currently a full-time professor at Western Carolina University, where I teach criminal law, criminal procedure, and criminal courts, and I still maintain a law practice in Decatur. I am very familiar with the cost of prosecuting juveniles as an adult at 17 for that juvenile. Interestingly, when Mary Margaret called me last week about coming to testify here, I got a phone call 2 hours later from Governor Cooper's office in North Carolina. North Carolina is one of the 7 states, along with Georgia, left, and they are looking at raising their age of what we call criminal responsibility to 18 as well. Here's the bottom line. In Georgia, we have a 17-year-old who is arrested. He or she is taken into custody. There will be a mugshot. Now, that case can end up in various different outcomes. For example, some prosecutors in Georgia, such as Barry Morgan and Cobb County, will have a diversion program for most 17-year-olds, and at the end of it, that case will be dismissed. However, the prosecutor in Forsyth County is opposed to diversion, so that young person would have to take a first offender status, even for such as a disorderly conduct. Here's where the rubber meets the road, though. Our kids in Georgia compete with kids in 43 other states for college applications, grad school applications, and jobs. I help many of my former clients with applications for all of these. And the first question on every application is, have you ever been convicted or arrested or pled nolo or entered into a diversion program or first offender? And the kids in Georgia, the 17-year-olds, if they answer truthfully, and I tell them you must answer truthfully, they will have a black mark against them where the kids in 43 other states would not. So the kids in this state who, like I said, have to compete with their peers all over this country, and I'll give you 2 very distinct examples. I represented a young man several years ago who at 17 was arrested for less than an ounce of marijuana. He got the diversion program, went through Georgia Tech, and graduated in a master's in internet security, top of his class. However, he was prohibited from working for the national government, which I think we need people in internet security right now, because he was prosecuted as an adult at 17. Young woman I represent currently just turned 17, engaged in sexual intercourse with her 15-year-old, almost 16-year-old boyfriend, and is arrested for statutory rape. In North Carolina, that wouldn't even be a crime. In 43 states, that would be handled in juvenile court. The young woman now has an arrest for sex crime on her record. Now, the question is, where is the best place to treat these children? I work with kids who are 17 in the adult system, and I work with 16-year-olds. The juvenile court and the juvenile court judges are most adept at working with these issues. The 17-year-olds in our adult system, because we have so many people in our adult system, are just another cog in the wheel. With a 17-year-old, and we're not talking about the violent crimes. I'm in complete agreement as a former prosecutor. 17-year-olds charged with violent crimes at 440 crimes should remain in the adult system. However, the kids who go into juvenile court get more personal attention, more hand-holding, more probation supervision, and their needs are addressed better in the juvenile court system. I do not know what it would cost to put another 6,000 kids in the juvenile court system. However, I do know this, that if I was still district attorney, I would just move prosecutors, as the representative said, from the adult court into juvenile court to handle these cases. The bottom line is, though, our kids in Georgia should not be treated differently than the kids in the 43 other states. And the prosecutors and society certainly have fared well in those states. Nobody is looking to lower the age after they've raised the age to 18. And with that, I'll answer any questions I can.
Does anyone have any questions of Mr. Morgan? Oh.
Am I on? Okay. For the layperson who's not familiar with a lot of the legalities, could you just define for me clearly the difference between a violent and a non-violent crime committed by a 17-year-old that would pass the threshold, where that threshold is?
The legislature has already defined the SB 440 cases: murder, voluntary manslaughter, armed robbery, rape, aggravated sodomy, aggravated child molestation, aggravated sexual battery.
Okay. That's helpful. Thank you.
I think the real tough one is what to do about the repetitive burglary. That's what irritates my constituents. And are they included in the larceny statistics here? The burglaries. Those are the tough ones.
So burglary would not be included?
No.
No.
Thank you, Representative Cantrell.
Thank you.
Thank you, Mr. Morgan.
Thank
No
you,
further
Representative
questions.
Ballinger.
Thank you.
Cool. Thank you, J. Tom. Secondly, please, Melissa Carter from the Barton Center. And there are materials in your packet. Each of you have a packet from most of the folks that are talking today.
Ms. Carter, welcome to Juvenile Justice.
Thank
It's a
you.
pleasure to see you.
Thank you. Likewise. Madam Chair and members of the committee, thank you so much for, one, inviting me to speak, and Representative Oliver, but also for taking the time to really start some thoughtful dialogue about this issue. The issue of raising the age, as Representative Oliver said, has really been an interest of the Barton Center and those of us who were part of the architecting of the new code that was effectuated in 2014 and the subsequent juvenile justice reform since then. And so for well over a decade, we've been looking into this issue and following the trends that are occurring in other states and looking deeply into their experiences. And their experiences certainly involve looking into their budgetary experiences. So I'm going to do my best to walk you through the fiscal note that's been provided to you on the bill and to raise for you what I hope to be some greater precision about the gaps that we have in information and where I see some possibilities for further refinement or elaboration on what's happened in the fiscal note. So as you all have, I believe it's in your packet. The Department of Audits and Accounts did produce a fiscal note, as Representative Oliver has already shared, on House Bill 53. You can see for yourself, but the high-level summary of this is that the Department of Juvenile Justice estimates one-time costs at $110 to $150 million, essentially for capital construction costs for new hard beds, as we've referred to them, in their regional youth detention centers, which are their short-term facilities, and in their youth detention campuses, which are the long-term facilities, the juvenile equivalent of jails and prisons. So they're looking for more, understandably more bed space, as well as an increase of $33 million for facility operations and community services. So once the kids are released from restrictive custody, or for those who don't go into restrictive custody, obviously they're being supervised in the community and increasingly engaged in really critically effective evidence-based programs that are meant to reduce recidivism, prevent them from reoffending. So there is a cost estimated there. And then an additional cost that has to do with personnel for intake and assessment practices. Additionally, the Department of Behavioral Health has suggested an increase to their budget on the order of $5.1 million for the kinds of forensic and competency evaluations, assessments, and services that they provide for our juvenile population. And then finally, as has already been raised, some additional costs factored in here for attorneys, both on the prosecutorial side as well as the defense side. Your total then gets you well into close to $200 million. So while astonishing on its face, I hope to be able to provide for you some context about how this has looked in other states, as well as, like I said, to raise for you some questions that I have about what was considered, what hasn't been considered, what's worth further investigation, based on, frankly, our own efforts to acquire the data that would allow us to do this kind of projection and inform this kind of conversation. As you've heard, we do know the number of arrests of 17-year-olds. That's a great place to start. So we have 7,452 arrests of 17-year-olds in Georgia last year in 2015. I want to re-emphasize to you that that is a number that has been showing a downward trend. So declining overall trends in crime committed by 17-year-olds, and of course that's the population we're talking about, in addition to declining overall trends for all of juvenile crime of any age. What we also know is that this is what we know from some earlier fiscal studies on this, about 92% of those 7,452 17-year-olds are first-time offenders. And we also know that of those, so we have about 8% of those then are arrested 2 or more times. So we know something about how they might be managed and the analogs we would draw between how they would experience processing in the adult criminal justice system and how they might experience something different in the juvenile justice system. Because the two systems certainly have parallels, but they're different. Both different in their focus, the purpose for the interventions, and the kinds of timelines that apply, and the decision-making that applies, and the dispositions that apply. And so in thinking about that, one thing I would raise for you as you consider further study of this issue is that that is not what we have available to us in any of the fiscal analyses that have been able to be produced. Understandably, these fiscal analyses have focused on those hard costs, those real cost, immediate direct costs to the systems that are impacted by the shifting of this population. But what we don't have is a comparison about that individual case that's a misdemeanor or a felony and how that is experienced in the adult criminal justice system versus how it would be experienced or processed through the juvenile justice system. One example I can tell you, even from clients that we have at the Barton Center, for the very same offense, co-defendants, one who was 17, so an adult under our current process, one who was 15, who went to the juvenile justice system. Our adult client spent 3 months in jail waiting arraignment, so pre-arraignment, 3 months in a county jail, sitting. Nothing happening, just sitting, and we're paying for that. The juvenile who was involved, within 30 days, was fully disposed of in his case and released back to the community. I'm not questioning the outcome. I'm just sharing with you at least nothing else than the sort of the expediency looks different on both sides, and those costs are just different on both sides. And so there's something to the quality of the experience that I think we have to take into account and value at a dollar amount, and that is not available to us in the fiscal notes that we have. Does that make sense? I hope that makes sense. Representative Oliver also mentioned that this shifting of this 17-year-old population currently seen as adults to the juvenile justice population is also playing on the trends that we're continuing to see. One, around diversion programs, as have been mentioned, and that's certainly been a pillar of the juvenile justice reforms that have been enacted by this body in the last few years. And then, again, the overall juvenile crime trend decline. And so those two things have been the factors that have been most cited when we look at the experience of other states who have projected very high fiscal costs, at least initial upstart costs, to shifting this population from adult to juvenile. We've seen, and again, states are so different in terms of the volume, the population, numbers that you're actually talking about, as well as their sort of landscape for how they manage it, that the numbers themselves may or may not be helpful in comparison. But certainly you see numbers on the order of what we're looking at here. $200 million is not in any way out of the stratosphere for what these costs look like when they're projected for other states. But I think importantly to share with you, every other state that has done this, that has published their fiscal work, has not seen those projected, those anticipated costs materialize. And I think that's really important. I realize in some ways that's a leap of faith when you're talking about an appropriations bill, but I do think it's something that we can study further and learn from. So, for example, in Illinois, when they took this on, they anticipated and built their budget, their appropriations out, predicting a 35% increase in youth in the juvenile justice system. The 35% increase never materialized, both because, again, of the overall declining trends, but also of a capacity within the system that was not able to be valued that actually could absorb the transition of those children. I'll continue to say, we've also seen that in North Carolina, they projected $49 million for the first year. They actually realized over time $102 million a year saved, so a complete reversal of that projection. Connecticut projected $100 million, saw at least initially costs remaining flat. Massachusetts projected costs ended up being 65% less than their actual costs. So a far cheaper, if you will, a far more cost-efficient model to bringing these kids into the juvenile justice system. Other states have specific data points. Texas was able to cut $100 million from prisons. Now, they're still a raise-the-age state. Their proposal's pending there. But through other reforms, they've used these numbers as instructive. Arizona talks about a diversion program working with teens, saving them $84,000 a year per teen. Wisconsin looking at a projection of a savings of $5.8 million per year for every 1,000 youth diverted or returned back to the juvenile system. Now, all that's a little bit like monopoly money. I think at the end of the day, when you really are trying to lock down apples to apples kinds of comparisons, it gets very tricky. I think the trends are very important to observe. And here, I would go back to a couple of trends worth observing here. Through the juvenile justice investment grants that we've seen, as that's really, again, been part of the engine of reform for the last few years, I would remind the committee that in the first year, we saw a 62% reduction in out-of-home placements, and that was 1,100 children. In year two, an additional 54% reduction, 1,600 children. Year three, 53% reduction, 1,700 children. These are children who've been diverted through effective, evidence-based, community-based alternatives to detention. So they've been diverted from detention into community-based services and programming, meaning something, right, a reflection on that hard bed cost at some level. And then finally, I would say that, as you're well aware, that this is more than just a budget conversation. This is actually a policy conversation. And so in addition to those hard costs and figuring out what goes in what column, what offset what, there are also a whole host of cost avoidance considerations that I think are worthy of considering and that have been factored in other states. Because what we're really trying to do here, the shifting of this paradigm is not just about money, it's actually about how to work more effectively with youth so that we get the kinds of savings, both socially and fiscally, that come with reducing recidivism, reducing juvenile crime, restoring kids to more productive lives in society. And so you'll see in other states, for example, Illinois has a fairly comprehensive report that factored in the sort of avoidance cost of economic destruction caused by an adult felony conviction. All those collateral, permanent, long-time consequences that come from the kinds of experience that J. Tom Morgan was mentioning. So there are these other kinds of considerations, and I think we need to figure out where we want to draw the boundaries around this issue to consider what those cost savings measures might actually be from the fact that more effective interventions in the juvenile system will lead to a reduction in recidivism of juvenile crime, will lead to less adverse costs absorbed by society, people, the communities. And then finally, on a more sort of technical and concrete level, with respect to the fiscal note that you have, in addition to the considerations I've raised, there are some specific missing pieces for me that leave me really scratching my head based on the understanding and work that I've done in these systems. Be aware that the Department of Community Supervision does have some responsibility statutorily for overseeing 17-year-olds who are released from restrictive custody from a Class A designated felony. Just be aware that they have some responsibility currently for 17-year-olds, and they didn't have a contribution to this fiscal note. As well as, and perhaps more importantly, we have at least 10, it depends on how you define them, what we call independent juvenile courts, meaning that those are county-based probation. So there are a whole, and that number is entirely missing from this fiscal analysis. We have a whole lot of shifting population from county to county that don't hit these state systems that are costed out here for you. So not just in thinking about the number going up, but also offset, because we don't have those numbers on the adult side either. It really goes back to Representative Oliver's comment earlier. Because of the localization of data, because of the lack of customary and routine data collection reporting on this specific population, we actually don't know how many 17-year-olds are currently sitting in county jails. And so therefore we can't predict the treatment of county jail would equate to, X equates to Y on the juvenile justice side, and we can't make those projections.
Here's a question. 17-year-old foster care in a county jail. Who issues bond? Who brings up the bond for that child? Time and time again, it's a little issue, but it's incredibly illustrative issue about how 17-year-olds don't fit anywhere. Foster care child, we the General Assembly and taxpayers have responsibility for. We're paying the jailer to house that 17-year-old, and nobody's going to post bond. Totally bad management of state resources and the life of that child.
Thank you, Representative Oliver. Ms. Carter, do you have anything to add?
I don't. I would just say that what we do know, where we fill in the gaps, are with endless amounts of anecdotes showing this inconsistency, this discrepancy in our policy treatment of children. We see the 17-year-old who's home when the house is raided, arrested as a party to the drug offense crime, whereas if a different paradigm, that very same child in that very same circumstance would maybe enter foster care and require the state's protection. So these incongruities in the way that we deal with children in our current scheme certainly are the ways that we're thinking through the blanks that we don't have as a matter of data. But that there is a data development agenda. We can go get that data. Political will would certainly help us fill in those blanks more concretely and help make the decisions that need to be made about the contours of this particular issue.
Okay.
So thank you.
Thank you. Who's 29? Oh, yeah. Yes. Okay. All right. Yes. Your question?
Thank you, Madam Chair. This is for Representative Oliver, I guess. I know House Bill 116 is going through judiciary non-civil, and it's actually in the same section, and so it kind of expands on those cases that will get kicked up to Superior Court. They seem to go opposite directions.
They're going opposite directions.
They're in opposite committees, opposite directions, and it would be nice to have them in front of us in the same committee so we can deal with them, because worst case scenario would be is this bill passes first, that bill passes second, and then that bill overrides it and kicks it back down to 17. So I would assume the last bill takes precedence. So I'm just curious, is there a reason why we aren't looking at these together in a more comprehensive fashion?
You can ask the Speaker the assignment.
We can certainly discuss that, and it's certainly something, I think our judiciary committees, we have Chairman Willard who chairs judicial civil. I certainly think that we try to work in concert together, so hopefully we'll be able to eliminate any incongruities, but I appreciate you bringing that
Yeah,
up.
thank you, Madam Chair. The worst thing, and
I
like
sit
you
on
said-
both committees, by the way.
Yeah,
so.
the challenge for me, and like you said, I don't get to make the rules on the last day, but my personal concern would be is if I, voted for something like this and then it got amended to add the 17, and then I'm voting to stick, 17-year-olds in expanding the conditions that we send to Superior Court. So that I just wanted to voice that concern
Okay.
now. Thank you.
I appreciate that. Thank you. Representative Cantrell.
Representative Oliver, would there be a reason to consider the offender status of the 17-year-old, such that if they were first offender, being, juvenile, and then, but if they were second or more, going in the adult system, would that be a reasonable idea?
Other states have pushed out implementation of raising the age, and they have in some cases gone with misdemeanors first and then felonies later. In other cases, they've tried to do something like you have done. We already have Ms. Carter found this statute because she's a better lawyer than I am. We already have a statute in our code that gives us opportunities to address the 17 to 24-year-old, 49, 9 something, 72, something like that. There are ways that we already have that power, but we aren't using them. And one of the benefits of this discussion is exactly that kind of question. Because the district attorneys do very different things now, very different things. And how much is consistency statewide of value to us in relation to protecting the low offender 17-year-old?
Thank you.
Thank you, Representative Cantrell. Representative Thomas.
Thank you so much, Chairman. I just wanted to, I was going to say something about the foster care part, and I appreciate you bringing that up because we have over 12,000 kids in the system, and they will be subject to being tried and not being able to have anybody there to get them out of jail. And so I think this is really something that would help these kids in the foster care system. Thank you for that. And I just want to clarify one thing. When Representative Cantrell asked this question about burglary, and you said it's not included in the statute, can you clarify that for me?
Burglary is not included as one of the 7 deadly sins. Burglary traditionally has been viewed as a property crime and nonviolent. Where that gets, but it's the thing that terrifies people because of the words home invasion. So I raise that as a practical matter. What to you is nonviolent is a low offense would not be a low offense nonviolent to another person. And burglary is just an example where people, having been burglarized twice myself, I know how it feels. So it's a tough one. There is a federal mandate that we track what we call dually engaged foster care children who are in the delinquent system. Others can tell us what percentage of that is. It's pretty high, though. Is it 9% or lower, higher than that?
It's higher than that.
It's higher than that, and that's a very relevant factor. Are we in compliance with federal law and how we track the dually enrolled foster care child in the criminal justice system or not?
Okay. Thank you.
Thank you.
Thank you, Representative.
Marissa Dotson from the...
Ms. Dotson?
And as she's coming forward, one of the benefits of us having some discussion later on is what do your juvenile court judges think? What I see them as being divided on this issue. Give you a chance to ask your juvenile court judge what he or she thinks about this particular issue.
Thank you, Ms. Dotson. I appreciate it.
Thank you so much, Chairwoman Bellinger. Thank you for the opportunity. My name is Marissa Dotson. I'm the Public Policy Director at the Southern Center for Human Rights. The Southern Center is committed to advocating for improvements to the criminal justice system on behalf of those affected by the system. We have worked for many years with the Council for Criminal Justice Reform, with the Governor's Office, and with members of the General Assembly to realize some very beneficial changes to the criminal justice system. We agree with all of the previous remarks in support of House Bill 53. I only wanted to offer 3 additional reasons to support House Bill 53, and those are, excuse me, the maturity of the 17-year-old brain, the likelihood of increased recidivism, when you treat 17-year-olds as adults, and the impact of having a criminal record, an adult criminal record, in Georgia. So the first thing I'll start with is the research is pretty clear that 17-year-old brains aren't developed and they're not as emotionally or socially mature as adults. In fact, the frontal lobe of the brain only begins to start maturing at the age of 17. It doesn't reach full maturity until the age of 25. That's an important part of today's discussion because this is an important part of the brain when we're talking about this kind of activity. The frontal lobe is responsible for projecting future consequences based on current actions, for determining whether to make good or bad choices, the ability to control impulses and emotions. Perhaps this lack of maturity is the reason why Georgia doesn't allow 17-year-olds to vote, to own a gun, to drink or buy alcohol, to engage in contracts, to marry without parental consent. So Georgia clearly recognizes 17-year-olds as children, just not when they make inappropriate and antisocial behavior. Further, we know that for the most part, when we're not talking about the SB 440 cases or those cases that are considered to be significant public safety concerns, that typically youth age out of committing these kinds of actions, you age out of crime. So in that sense, 17-year-olds would be better suited to have a system like the one that's in our juvenile justice system, to have access to counseling, educational resources, rehabilitative programs that would make a difference. Moreover, treating 17-year-olds as adults doesn't realize positive public safety outcomes. In fact, the recidivism rates are higher when we treat 17-year-olds as adults. There's been some recent research that's found that youth treated as adults actually have the highest rate of recidivism except for when it comes to drug offenses, and that the likelihood of recidivism or an arrest is 34 to 77% higher when 17-year-olds or when youth are treated as adults, and that they are more likely to engage in violent activity down the line. Why might this be the case? Well, 17-year-olds are highly easily influenced by negative behavior. They are, so when you treat a 17-year-old as an adult and you allow them to socialize with adults in the adult criminal system, then they are able to experience and be exposed to an adult criminal culture, more violent and antisocial behavior. We also know that this age group is more susceptible to treatment and rehabilitative services, so getting them early on in the process yields better outcomes for taxpayers and for our system. I wanted to highlight that several states have recently raised the age of majority and have seen positive results. In Connecticut, for example, they've seen a 51% decline in their youth in their adult facilities. And in Mississippi, they've seen a 21% decline in their youth in their juvenile justice system facilities. So it's actually realizing the kind of public safety outcomes that we hope for and not seeing the kind of increases to the system that some people are afraid of. And finally, I want to mention to you all the impact of having a criminal record in this state. So as was mentioned previously, juvenile records are sealed. We recognize that this kind of immature activity as a child should not affect you into your adult life. It shouldn't stop you from getting a job, securing housing, getting a license, and being able to take care of your family. Unfortunately, in Georgia, 1 in 3 Georgians have a criminal record, have been arrested or convicted of a crime. We are consistently found to be one of the hardest states in the country when it comes to being able to move on when you have a criminal record. What we also know is that more employers than ever before are considering criminal histories in the employment process. In fact, more than 90% of employers now conduct some form of a criminal background check. And we know that more than half of them will make a negative decision based on any type of criminal record, even if the person has never been convicted. So also what we know is that not only are more employers conducting background checks, but where you used to have a 5-year or a 10-year look-back period, a 7-year look-back period, now most employers are looking back over the adult life, essentially. And what that means is that you would have an individual who would have as a 17-year-old was arrested or convicted of a crime and have that offense follow them throughout the rest of their life and make it very difficult for them to gain access to jobs and housing and other opportunities that we know when people have access to stable employment and housing, they are less likely to be involved in the criminal justice system. So finally, I'll just, again, thank you for my opportunity today. I just wanted to remind you all that as we're thinking about treating 17-year-olds as children or putting them in the juvenile justice system, that they are children, that their brains aren't developed yet, that they're easily influenced, they're yet more susceptible to rehabilitative services, and that treating them as adults doesn't yield better public safety outcomes for us, and it's not a good use of taxpayer dollars.
Thank you. I appreciate it. You have a couple of questions. Representative Quick, I know you have to leave, so.
Thank you, Madam Chair, and thank you for your presentation. My question would be, is this just another arbitrary number in light of what you've said about the range from 17 to 25? And I commend you for trying to talk to General Assembly members about emotional maturity and brain functioning.
I think we could all probably learn something from that.
I think that there is a good point to make about where you draw that line. I think that states that are, we have states like Connecticut and others who are considering increasing their age of majority to 21 or thinking about how you might deal with this population differently. So I think this ask is about at least recognizing 17-year-olds as children in the same ways that we do in other parts of Georgia law. Southern Center would be in full support if there was a decision to move it beyond 17 for sure.
Any determination by age is arbitrary. So you have to look at evidence. We in Georgia choose to give the power to 14-year-olds to choose their custodial parent. For instance, that's certainly an arbitrary designation for a minor to make a very important decision. But I think that we have to look nationally at what it is really meant for children to be treated as adults in criminal offenses.
Thank you. Chairman Welch.
Ms. Dodson, thank you for being here today. I'm going to go back to looking at the language of the bill because I'm still, and we've talked about this before, and I've talked about this to Representative Mary Margaret Oliver as well, but under Section 5 of the bill, beginning on lines 45 actually, throughout the bill, it makes the distinction between, in the code actually makes the distinction between under the age of 18 years of old is the revision. So the code says under the age of 17 or before the age of 18. It qualifies the number. There's language surrounding the number. And that's the way it is throughout the code and throughout the bill as you look through it. Section 5, however, does not do that. Section 5, the language of the code as it exists, refers to, for example, at lines 54, 55, the Superior Court shall have exclusive original jurisdiction over the trial of any child 13 to 17 years of age. So it's not before 18 or under the age of 18. I hope everybody's following. This is a very critical distinction.
Mm-hmm. It is.
So it says, and so the bill would revise that to 13 to 18. So an individual could be 18 years old under this code section. So we're not talking about 17-year-olds with respect to Section 5. You're talking about potentially 18-year-olds. And so the bill throughout goes through and shifts everything up to if you turn 18, then you don't get the protections that the bill is trying to seek. If you're 17, we're filling the gap of the 17-year-olds, except for Section 5. So I have trouble with this language because this language says that there's exclusive original jurisdiction over the trial of any child 13, and then as amended, the law would read 18. So you could be an 18-year-old age who has allegedly committed any of the following crimes. So I have some concerns about this language, and these are the 440 crimes. So the Senate Bill 440, the 7 deadly sins, so to speak. And so I have some concerns about that language. It feels like to me that the law, this bill as written, would would open the door for 18-year-olds to avoid prosecution in superior courts for the 440s, and then be transmitted down to juvenile court as an 18-year-old in those situations. So could you explain and address that concern I have with Section 5?
Yes, absolutely. And that is not the intent of it at all. So if it's a language issue, then we should deal with it, because the point is, in terms of what we're trying to do, is deal with that gap year of between 17 up to 17 and 364 days,
yes.
right?
Yeah.
So that if you are within that year, that you would still be subject to the SB being tried as an adult in these cases, and that once you turn 18 for all offenses, right, you would be considered the age of majority.
Yes.
And so I don't want to get into whether the language does that, but I know that is the intent. And if I can take just a second to talk about SB 440 and make sure we're clear with House Bill 116 and whether or not there is what would happen. So the effort to raise the age of majority to 18 does not affect SB 440 cases at all. That's not the intent. If we need to make sure to clear it up, because from age 13 and on, right, whatever that age is, if it's at 17 or 18, right, all the way up until that day, you can be tried as an adult in Georgia if you commit one of those crimes. What House Bill 116 is trying to do is add to that list of crimes, not change what the age of majority is, just suggest that a 13-year-old charged with aggravated assault with a firearm or aggravated battery on particular victims would be subject to treatment as an adult. This bill does not affect what would happen with SB 440 cases. I don't know if I've answered your question, Chairman.
Well, this language, so I think we're going to need to talk more about this particular section. This is the one that gives me the most trouble with the policy, because I think this goes, the entire bill refers to and qualifies the numerical value of 18 as being up to or under 18. This one section does not. And so this one section, as it's written, is inconsistent with and goes a year beyond the rest of the bill. So there may be reasons for that I'm not seeing, but I do want to understand that better.
Well, Chairman, I guess I would say to you that that's the current law. If you think about what we're trying to do, right? Right now, the bill says the law is 17, which essentially is is the issue we have, right?
So why change that? Because
we still have the issue between up to 7. So if I'm 16 and 364 days, right? I'm still a minor under the law in terms of criminal justice.
No, not in this section. In this section, it's 13 to 17.
Right, but what I'm trying to say to you is that once you hit 17, it doesn't matter what you're charged with. Once you hit 18, it doesn't matter what you're charged with, right? If the law changes so that the age of majority is 18, it won't matter what you're charged with. What we're doing here is saying is if you're under that age, and right now it's 17 because that's the age of majority, but if you're under the age of 18, you can still be tried as an adult. It's just I think the change is only trying to catch that gap year between 17 and 17 and 364 days.
It's arguably true that this distinction you're putting out has no significance on how anybody is treated were this to pass. I think that's what Jill Travis and I talked a little bit about that, and I think it's my conclusion that this distinction you're putting out is a distinction, but it has no practical impact on the implementation of either 440 or 53. But that's something that we should be sure about, other than me just telling you that's my opinion.
Yeah, see, and I have the opposite.
Right. And it's a fair, certainly believe it's a fair question. Absolutely.
Thank you, Chairman Welch. Thank you, Representative Oliver. There's another question down at the end.
Real quick one for you lawyer types. To add on to his question, I guess, what is the age of 17? Is it 17, or is it like 17 in a day? Where do you fall?
If it's on your birthday, then you're an adult.
So 17 in 2 days does the bill say 17 is the cutoff, and then once you reach 17 in a day, or is it?
It's on your birthday.
It's midnight the day that you turn 17.
You become an adult.
Okay, so by changing it to 18, you would be midnight of 18.
That's right.
Yes. Okay.
Okay. Thank you. Representative Raffensperger.
This is really just a legal question. Thank you, Madam Chair, to Representative Mary Margaret Oliver. And because I'm not a lawyer, are there on line 61, you have aggravated child molestation. Are there different types of child molestation? In other words, so if you've committed aggravated child molestation, you automatically would go up, but are you saying that there's other types that where you would not be? And is that something that we would want to do? Because I think that child molestation
I do apologize, Representative Ravensburger. I'm just going to take the chair's privilege and just kind of interject there. That would be a change. I think that would be dealing with the 440, what's automatically bumped up to Superior Court, what is and is not considered a 7 deadly. There is a lesser offense of child molestation that is less involved than aggravated child molestation. So, but you and I we can talk offline about that. So.
You're pointing to one of the most discussed areas of the 447 deadly sins, though, because sexual offenses committed among minors, like the 16-year-old, all of that is part of the history of the discussion and for and against.
And whether or not they're perpetrators or whether or not they can be
They're
perpetrators
victims.
or they're acting out or victims or whatever. So you as a former child advocate, we can chat as long as you want about that. So anyway, Representative Oliver, do you have any other additional witnesses?
Polly McKinney from Voices.
Ms.
The
McKinney?
last folks that I wanted to bring forward today, just briefly.
Okay. Just kind of for everybody's scheduling purposes, we're going to hear from Ms. McKinney. Once she finishes up, we're going to hear public comment. We have a couple of people that have signed up to add a couple of public comments, and then we will conclude. So.
Madam Chair, I just wanted the committee to know this is Tom Rawlings, who's a governor's appointee child advocate, has been on the job 3 weeks. And is
Previously held the position.
He's a former juvenile court judge and will be a very good help to us as we go forward.
Yes. Yeah. Well, thank you for joining us. We certainly we are very sympathetic about having to leave for another meeting. So we look forward to working with you. Thank you. Ms. McKinney?
Hi, I'm Polly McKinney. I'm the Advocacy Director at Voices for Georgia's Children, and we have come to talk a little bit about the trauma children would experience and do experience in the course of life, but also in the confines of the criminal justice system. In your folders, you all have one of these, which is a broad look at childhood trauma and what it does to kids and what their outcomes are and some recommendations. But to get into more of the weeds, I'm going to introduce you to my associate, our policy director, Erica Fenner-Sitkoff, and Erica is going to give you very brief comments on trauma regarding this subject.
Thank you, Madam Chair. Thank you, Representative Oliver. You've heard about brain development in 17-year-olds, and so I'll be very brief to talk about the impact of trauma on brain development. Research reveals to us that 75% of the youth involved with DJJ and 90% of the youth in secure DJJ facilities have been exposed to some type of trauma. And research also tells us that anywhere from 50 to 80% of the youth in secure facilities have experienced 4 or more traumatic events, or what's otherwise known as ACEs, adverse childhood experiences. And we know that the critical mass of ACEs where trauma starts to impact brain development is 4. And what 4 events. And so when you think about the experiences that 17-year-olds, as Ms. Carter was saying, the difference between spending 3 months in an adult jail versus 30 days involved with the juvenile courts, there's a lot that they can be exposed to in that time. ACEs is everything from witnessing violence to being a victim of crime yourself, homelessness. So as you can imagine, they can be exposed to quite a bit more traumatic experiences during that period of time. And given that the brain doesn't solidify in its development until you're 25, as we heard, there's a lot of opportunity for therapeutic intervention, evidence-based intervention, where we can see a positive difference in those youth. For example, integrated treatment for complex trauma, trauma-focused cognitive behavioral therapy, all of which we have documented effectiveness for teenagers, including 17-year-olds. So we recommend and ask that the committee think about the impact of brain development, specifically trauma, as you move forward through these committee hearings, and we're happy to be helpful in any way that we can as you think about that.
Okay, thank you. Thank you, I appreciate it.
Thank you, Madam Chair.
Thank you, Representative Oliver. I appreciate you bringing this issue before our committee. Mr. Smith from the DJJ? Thank you, Mr. Smith. I believe we've met in my office. So,
yes, ma'am. Thank you, Madam Chair.
Yep.
And members of the committee. I just wanted to give a few thoughts on a few items that have been discussed.
If you could move the mic. I do
Sure.
apologize. We
Yes,
are
ma'am.
kind of streaming, so I want to
Certainly.
make sure that we remain accessible for those that can't physically be here. So
Yes, ma'am.
I appreciate that. Thank you.
So again, my name is John Smith. I'm with the Department of Juvenile Justice. And so just wanted to shed a little bit of light on some of the questions that have been raised while discussing the fiscal note and the projected impact on the department. I believe as if you could find consensus among the subject matter experts at the department that no one would detract from the merits of raising the age, but did want to point out some things that were raised previously. We have a study that is forthcoming that has been produced by ARS and Dr. John Spear, who's a PhD criminologist. And it's really a comprehensive report that has taken a look at raising the age to 17 and how that would play out in our system. Just to give some perspective, we have 19 RYDCs, which are the short-term facilities, and 7 YDCs, which are the long-term facilities. And currently, we see a projected significant cost with moving forward with this legislation, but really just want to be a resource as we discuss this and provide the best data and information we can to be as helpful as possible. Basically, what the report has done, and I apologize that it's not out yet. They were waiting for fourth quarter data from the GCIC to make it as accurate as possible, and that's kind of where the delay's been. But I believe this coming week, there should be something out on that. But what they did is they took arrest fingerprint data from GCIC and scrubbed it thoroughly, case by case, and ran 10,000 model projections and took the 25 to 75% quartiles and created this model that generated the 152 additional YDC beds. And looking at our system currently, the point was raised about the reduction of beds from reform, and that is accurate. We have seen a reduction of beds as a byproduct of reform, and it's been a positive thing. We have reduced 223 beds. The majority of those are in the YDCs, the long-term facilities, which would ultimately house the majority of the 17-year-olds that came over. The data that I have is not coming from the uniform crime reports, which is what are compiled by reports sent in by police chiefs and whatnot. It's kind of on a more voluntary system. What we're using is actual fingerprinted arrests out of the GCIC system. And we've seen something very similar to what's been mentioned. From 2007 up until 2014, there's a significant decline in arrests, and I think that's been true nationwide, but especially in Georgia. From 2015, though, to 2016, this past year, for the 17-year-old population, fingerprinted arrests, there's been a 67% increase. And so that's part of I think where some of the concern comes in is that we're seeing for this past year from 15 to 16, fingerprinted arrests in GCIC, there's been an increase across the board. And so when you're trying to project something, there's obviously, you're seeing a system kind of in flux, and there's people that will point to macroeconomic data to why that happens. But regardless, you're kind of seeing something in flux. And then I wanted to also point out just our rationale on the 90 17-year-olds currently with the Department of Corrections. I think that figure can be misleading. So 17-year-olds, if you took them and put them in our system, you then have a stacking effect. So year one is 17 or 90 17-year-olds. On average, they're there 2.5 years, and that's what our current YDC population is seeing. So they're still in the system. Year 2 comes along, you have 90 additional, so then you're up to 180. And so you have this stacking effect that's put into the simulation, and that's where that 152 comes from. It's not a, so currently we're holding them until age 21. And so that's where that backlog builds up, and the 90 figure is somewhat misleading on what we would see coming in the door. And then lastly, I just wanted to just point out, just for the sake of having this conversation, and again, want to be a resource and as helpful as possible on pulling data and kind of coming up with a realistic model. The South Carolina and Louisiana, they have, I believe it was 2016, they took the approach of raising the age. And I think when it went into implementation, there's a bit of an implementation concern there, and it's been adjusted to where South Carolina has pushed back implementation to 2019, and Louisiana has done pushed it back to 2020. So there's a little bit of a I think there's great unknowns, and I think that's been demonstrated by previous speakers. But I want to just illustrate that some of this data that has been pulled has been thoroughly looked at, and I think there'll be a report forthcoming in the next week that will help shed some light on those things. But again, as we move through this process, just wanted to offer the department up as a team player and a resource to scrub this the best way possible.
Okay, all right. Thank you, Mr. Smith. You have a question, Chairman Welch.
Thank you, Madam Chair. Mr. Smith, tell me how long, or what's the age at which the Department of Juvenile Justice holds children? What's the oldest?
20 years old.
20 years old?
Yes. So they would leave the system on their 21st birthday.
Okay. So then, okay, and then and you said there was a 65% increase, 65% increase in GCIC over the last year, is that correct, for
Yes,
17-year-old?
Yes.
What were the actual numbers? Because 75%, 65% could be, out of 10.
So so in 2007, the number was 16,000.
Okay.
2007, and we saw a downward trend. 2008 was 6,000, and then it's increased in the last year to right under 10,000 is the data that I have.
So 2016 was how many?
2015 to 16 was so 6,000 in 2015, and then an increase of 67% for 2016, which I believe puts that number 9,000 and right under the 10,000 range.
Okay.
Anything? Okay.
Okay, and so just to make sure I understood what you were saying, though, you're saying that that the trending data is that you're seeing, of course, more, and then that would be the facilities that you currently have. Sorry, when we're talking about GCIC data, we're talking about data this is where a fingerprint has been logged in. So this isn't an actual conviction.
That's right.
So what we really need, we don't really need those numbers. Those numbers don't tell us anything. They tell you a trend as to how many arrests are being made, but they don't tell you actually how many are being convicted. So when we're talking about housing of children that have been convicted, juveniles that have been convicted and that have to be held in an RYDC, then I think we really need to know what those numbers are to have an actual outlook, because that's right. Those trends, I think, are the material trends that tell us how many beds we need.
Yes, sir. And I'll to reiterate the point that data will be housed in that report, that 4-month-long study that's coming out this coming week. While that report was being put together, that distinction is obviously made that those don't immediately translate into. I mean, it's a different number,
right.
And so what they have done is put filters on. Pushing out cases that wouldn't meet the threshold of prosecution and et cetera. So there are filters put on that to to put together the most realistic projection model possible.
And this may be answered in the report as well, but then are we also accounting for those that are located in jails, local jails? Will that be also looked at in the study? Do you know?
I believe it so, in the sense that they're working off of fingerprinted arrest, and so I believe that would trigger that, and so those would be in there as well.
I just anything further?
No.
Okay. Thank you, Chairman Woods. I just have a quick question. The slightly under 10, 65% increase, was that 2016 numbers that you had?
That's the number that I was getting. Yes, that's
okay.
Correct.
All right. I look because the information that we've been provided for 7,452 arrests of 17-year-olds in 2015. The 65% increase would be an additional 4,844, which would give us a total of 12,296. Which would conflict with the the percentage increase that you indicated would be significantly less.
And there again, I'm not sure where that data is coming from.
Okay.
There's two ways of pulling that.
Mm-hmm.
The uniform crime report that's put together, that is a collection of reports of arresting agencies around the state.
Mm-hmm.
And then the other way of looking at it is pulling the actual fingerprint arrest entry into the GCIC system.
Okay.
But again, I'm happy to. When the report comes out and further scrub that to make sure that we have an accurate data set on that.
All right. Piece. Just if I'm presented conflicting information, I'd just like to kind of sort that out.
Certainly.
So
yes, ma'am.
I appreciate that. There are no additional questions, but I appreciate your being with us.
Yes, ma'am. Thank you.
Thank you. All right. Thomas Weaver. Mr. Weaver, welcome to Juvenile Justice. We will keep you on a, we are under a time constraint, so just be aware of that, Mr. Weaver. Appreciate it.
Yes, ma'am. Madam Chairman, Representative Ballinger, members of the House Juvenile Justice Committee, I'll be very brief and concise and succinct with my comments. I support the legislative proposal that's been authored and tendered before you today, House Bill 53, by Representative Mary Margaret Oliver. I support the gist of what she's trying to do, but I had looked into some things on my own end, and I appear before you just as a concerned citizen, and I want to show you just how large and complex Georgia law is in regards to what Georgia law currently considers a child versus not a child for the purposes of many different facets of our criminal justice system and many different various offices that the General Assembly over the years has created to manage and help and offer support and rehabilitation services to children. In some instances don't even capture 17 years of age, which tends to be the concern here. Unfortunately, I was only able to get one draft of this copy made before the committee meeting with time constraints. So if it's permissible to the chair, perhaps I could pass it around after my presentation's through, but that would be her discretion. Saying that, this bill, one thing that I do want to share, and this goes to what another one of your colleagues had mentioned before his departure to go to another committee. I'm very aware that the House is currently taking under consideration a separate bill that would govern those specific offenses that would catalog an individual who is at least 13 years of age directly to the jurisdiction of the Superior Court without juvenile court jurisdiction. And I would be opposed to any consideration by this committee that would seek to lessen or eviscerate that public policy. But absent that concern, I don't find anything else that would tend to be a disservice to the citizens of the state. And I think, in fact, that this legislative proposal would be for the betterment of persons who, for want of other legal reasons, are not able to, for more or less, govern themselves absent legal constraints. So.
Thank you, Mr. Weaver. I appreciate your comments today.
Am I allowed to maybe pass this out to your colleagues?
People are free after once we have adjourned. People are welcome to get that information from you.
I'll leave it here.
Okay. All right. Thank you. Danny Porter. Mr. Porter, welcome.
Good afternoon, Madam Chairman, members of the committee. My name is Danny Porter. I'm the District Attorney for the Gwinnett Judicial Circuit. I'm also the legislative liaison for the District Attorneys Association of Georgia, and I have also been a member of the executive board of the of the Department of Juvenile Justice. So I think I have a fairly broad view of juvenile justice in Georgia, and I'd like to make a short statement and then try and answer some of the, at least one question that was raised by Representative Welch. This is a hard topic to talk about when I spent from 6 p.m. on Saturday night until 6 a.m. on Sunday investigating a murder that was perpetrated by two 17-year-olds and a 21-year-old. Now, I realize that this bill would have no effect on that case, but when I look back over 2016 and realize that we prosecuted an increasing number of 17-year-olds and younger, including a 14-year-old who called for a pizza delivery and robbed and killed the Domino's guy, and all he took was the pizza. He left the guy's wallet and keys and car, but he killed a man over a pizza. It's hard for me to think about raising the age of responsibility when what my knowledge is that in the last 2 years, we have seen a significant increase in the number and violence of younger offenders. And that is, when we put this question originally to the members of my association, my email blew up with exactly that same statement, is that we are fighting, trying to deal with a larger number of juvenile offenders. Now, I sat on the DJJ board and I listened to the monthly reports about the decrease in juvenile crime. And those numbers are there. I'm not going to lie to you. Those numbers are there. But I always had to make sure that we didn't just say because we weren't counting people or because we weren't incarcerating people that we were actually reducing crime. And I'm not sure that we can make that distinction at this point. I know from speaking to law enforcement that for the vast majority of the non-440 offenses, it's just not worth the paperwork to take juveniles into custody anymore or to charge juveniles. And I know in my own circuit, there's been a significant decrease in juvenile detentions and juvenile complaint forms, and it's not because there's been a reduction in crime. So I think we need to look deeply at those numbers, and we need to look deeply at what appears to be an increase in 17-year-old violent crime. That being said, if it becomes the will of the committee and it becomes the will of the legislature to raise the age of criminal responsibility to 18, then I think that in this interest of public safety that we're going to have to go back and look at the SB 440 bills. We're going to have to go back and look at those crimes because there are an increasingly broad range of crimes that prosecutors of the state believe have to be put into that batch if we're going to really seriously consider public safety. Also, in answer, I think we also have to look at the logistics of this, the nuts and bolts and the dollars. And this sort of brings me to Representative Welch, your question. I think I have not seen the fiscal note, but I think the fiscal note was created as part and included the costs of an ongoing process that you're aware of through your work in appropriations, where both the public defenders and prosecutors in this state are working in an incremental way to try and increase the number of public defenders and prosecutors across the state to handle the current loads in those underserved areas, particularly in South Georgia. And so last year there were 15 prosecutors who were funded by the legislature that were deployed mostly in multi-jurisdictional, multi-county circuits throughout the state, and there were also public defenders who were funded so that those juvenile courts in those circuits can actually have representation on both sides of the equation. And I think the factors that were taken into the fiscal note are part of that ongoing process. I agree. In my office, if 18-year-olds went into juvenile court in Gwinnett County, then instead of 3 prosecutors, I'd have 4 prosecutors. But most DAs don't have that luxury. Most DAs don't have even the luxury of assigning a single ADA into a juvenile court. So I think that is the reason for those numbers that you're seeing in terms of additional representation personnel. And that's really the position of the DA's Association. I'll be happy to take any questions.
Okay. Representative Oliver.
Do you know how many 17-year-olds are in the Gwinnett County Jail today?
I can find that out.
Can we find that out statewide?
No.
That's what I thought.
And I think that goes to going back, Representative Welch, to your question about convictions versus arrests. I'm familiar with the work that Dr. Spear has done, both in the juvenile system and in the adult system. And what we came to realize very quickly is because of the nature of the reporting and the nature of the data gathering, about the only accurate information that's available regarding criminal justice in this state is GCIC, arrest and fingerprint, and then everything else is an extrapolation from that. I can tell you that if you ask the clerk of court in Gwinnett County how many criminal cases there were, and you ask me, we would come up with two different numbers because we count them different. And if you asked every Superior Court judge how many cases they're handling, it would be different from my number. We have no unified criminal justice reporting across the
Some
board.
prosecutors would count a case as a defendant. Some would count how many different indictments they have or whatever. So that would obviously be different.
And that's been a continuing problem since I sat on the second Criminal Justice Reform Commission long ago and far away. And it's incredibly difficult to get accurate data, but we do know that the arrest fingerprint data is accurate.
I think you just highlighted a real significant problem. I mean, if I had signed a lawsuit, call 159 sheriffs this week and get 159 them to answer in this week how many 17-year-olds you have in jail, I could get that information.
If you assumed that you picked a uniform day, if it took your aide 3 days to make all those calls, then the numbers would fluctuate from day to day.
But it's obtainable. It's obtainable.
We can.
I agree. We're highlighting.
That's a subject for another bill.
We're highlighting our challenges.
Yes.
But, I mean, the clear challenge is that there's not uniform reporting of any of this data.
Yes.
Thank you.
Thank you, Representative Oliver. Thank you, Mr. Porter.
Thank you.
No further questions. Mr. Page? I'm not sure.
It's a tight fit over here. Madam Chairwoman and committee members, thank you for the opportunity to speak before you guys. First, I would like to thank Representative Oliver for the tremendous job you've done with trying to facilitate putting this bill forward. Also, the professor over at the Bart Law Center with Emory Law, thank you. My name is Sir Major Page, president of Black Lives Matter Greater Atlanta, which essentially means that we are the good group. We focus primarily on legislation and what happens after the protesting. And so from after protesting, now it's our responsibility to come into the state capitol, come into the city council hearings and the county commissioner hearings, and be able to articulate effectively what it is that what we want, and so I'm not a paid politician. I'm not a paid spokesperson. I'm just a member in the community doing what I believe is right for our community. As it pertains to House Bill 53, it is our position that we are going to support and endorse this bill. Certainly, when you look at the age requirement to purchase alcohol, the age requirement to obtain a firearm license, the age requirement to have a driver's license, and to get a pack of cigarettes. Certainly, the state of Georgia and every other state knows how to put those laws and restrictions and apply them accordingly. However, when it comes to crime and juvenile justice, we seem to want to prosecute young offenders as adults, and certainly we all know that juveniles don't have the same capacity, mind capacity, or developmental capacity to make full judgment calls. Sometimes juveniles are their mindset is cloudy, and so we would urge you guys to work in conjunction to work out the kinks in whatever in this bill if you find any, but to really support this bill and pass it. Black Lives Matter Greater Atlanta, again, us, the good chapter, we have created, because we recognize the need to really kind of handle and get it on the forefront with juvenile crime. Obviously, the gas station issue has, well, I don't want to put a crisis on it, but has really sparked a lot of outrage and a lot of concern. And so we believe that it would be disingenuous for us to say Black Lives Matter, but then be a willing participant and not speak out on really dealing with the issues in our community. So we have put together a council called the Atlanta Fulton Council for Solutions on Juvenile Crime. Certainly, when juveniles, when they offend, the first thing that comes into mind is to what? Put them in jail, right? And we believe that mass incarcerating our young people certainly doesn't fix or correct the issue, because once juveniles go to jails or prisons, eventually they get out. And then they go out and all the things that they've learned in prisons and these jails, they become hardened criminals. Now it's really harder to try to correct the issue, right? And so when you look at the cost and you're looking at the real harm that's being done, certainly we're not rehabilitating our young folks. And so I think that's something to definitely keep in mind. Lastly, we would also request that those members of this committee would also reach out to us, because we're saying that we hear you when you say, we're tired of y'all protesting, we're tired of y'all shutting this down. Okay, so we are working with legislators who want to work with us. And we're also intentionally going out of our way to work with legislators who may not see eye to eye with us. And so we would submit to you guys that we're ready and willing to work with different committees that really want to see our communities get better. And so, Representative Oliver, I would submit to you and ask you that you next time reach out to not only stakeholders who you deem to be key stakeholders, but reach out to us as the young people, because not one time have I heard from any young person. And so I would just urge you guys to really work with us, give us a chance so that way we can fight for our freedom as well. Thank you.
Thank you. I appreciate that, Mr. Page. And there is nothing further, so we are adjourned. Thank you.
Thank you.